Newsfirst, Newsline with Faraz Shaukat Ali on TV1.
And a very good evening to you and warm welcome to Newsline. Newsline finds itself once again in the capital of England, in London, and where our guest today recording is Dr. Gehan Gunatilleke, who is an attorney at law, and he's also a member of Sri Lanka's Human Rights Commission and a research fellow at the University of Oxford. Very good day to you, Gehan, and thank you for being on the program.
Thank you for having me. Yeah.
First of all, I'd just like to ask you, this is the basis of much of the program in any case. Sri Lanka has many challenges at the moment, and one is this anti-terror bill that is being proposed. Detractors say that there's no need, but there are others also who say that the PTA is not wanted. So PTA is not wanted or unwanted or over the top, and this proposed anti-terror bill is also apparently over the top. Does this mean that Sri Lanka needs no special laws to combat terror?
So for us, I think that's a really important question, because the PTA, this is the law that we currently have, has been on our statute book since 1979. It's been the subject of criticism for decades. So it's a unique opportunity to replace that law with a legal regime that is far more compatible with Sri Lanka's constitution and international obligations. Now the question is, do we replace it with another law, or do we approach this subject through the ordinary criminal law with a new offense on terrorism? And there's a debate on this, because these two options need to be considered. Now, obviously, the option that the government has gone for is a completely new bill, new law, the anti-terrorism bill. And the bill has certain weaknesses, particularly the March version of that bill. And taking into consideration the pushback, the opposition, the criticism, the government has revised the bill and placed it in the Gazette once again in September. So now the bill that we are considering is this revised version of the anti-terrorism bill.
Right. Yeah. So, Dr. Gehan, are there provisions in the ordinary law or in the PTA that can be brought into the ordinary law?
So the answer to that question depends on what we are trying to achieve through this bill. If what we are trying to achieve is simply an offense that covers the heinous crime of terrorism, well, we don't need a separate bill. We can introduce that offense into the penal code. Right? That's one way of dealing with that. If the purpose behind this bill is to remedy the problems with the Prevention of Terrorism Act, then amendments to the PTA would be the way to go. And in fact, the Law Commission, not long ago, I think in 2016, actually drafted a set of amendments. It came in the form of a separate bill, but it drafted a new bill that surgically implemented or enforced some of those concerns that were raised in terms of that, in terms of the Prevention of Terrorism Act as it stands. And those surgical insertions would have remedied the problems that had been identified with the PTA. So that's another way of doing it. The way that the government has selected is a complete overhaul, where the PTA is replaced with a new bill. Now, the problem with the new bill, if I were to say it in very succinct, concise terms, is that it fails to place trust in the Sri Lankan judiciary to basically carry out its functions. So the Sri Lankan judiciary is tasked with certain functions when it comes to the arrest and detention of individuals. It all flows from Article 13, paragraph 2 of the Constitution. Simply put, whenever someone is arrested or detained, it has to be on the order of a judge. That's what the Constitution says. Now, the PTA is a a blatant deviation from that principle. That happened in 1979. Now this new law needs to be compatible with that principle.
So, Dr. Gehan, back in 79, the government passed this PTA. But back in 79, the Constitution also said that there should be judicial review, oversight, and so on. So how did that get passed then?
That's a really important question. What happened was, back then we had the urgent bill process. Mm-hmm. So what Cabinet did was it certified the Prevention of Terrorism bill as an urgent bill, and essentially confined Supreme Court's role in that context to determining whether the bill needed enactment through a two-thirds majority plus a referendum, or just with a two-thirds majority. So, because the moment you certify it as an urgent bill and you also certify that Parliament plans to pass it with a two-thirds majority, Supreme Court's role is confined to deciding whether there's a referendum or not, and it decided it didn't. So that whole process happened within 24 hours, because urgent bills go within 24 hours. So I think that whole process was rushed, and Supreme Court at that point in 1979, without the benefit of hindsight, determined that although there were certain inconsistencies, ultimately because Parliament plans to pass it with a two-thirds majority, that becomes irrelevant to its scrutiny, and also found that no entrenched clauses are violated by the bill. Now, I don't believe for even a second that if you place the Prevention of Terrorism Act before today's Supreme Court, with the benefit of all the violations that have taken place under the purview of the PTA, the Supreme Court would have a similar ruling. So that's now a moot point, because you can't place the PTA before the Supreme Court. Supreme Court can't consider bills, or rather laws, that have already been enacted.
Right.
Which is why this opportunity now would be to look at the anti-terrorism bill and see whether it is compatible with the fundamental rights chapter of our Constitution.
Can you possibly give us one sort of comparison between what is in the PTA and what is proposed in the anti-terror bill, which might not actually go down well for the independence of the people?
So the PTA has a number of offences that are very broadly framed. Now, for example, making a statement that can be assumed or perceived as bringing about communal disharmony. Now, that's a very broadly framed offence. That particular offence has been used against journalists, against lawyers like Hijaz Hizbullah. It's been used in a variety of contexts because of how broadly it's framed. Section 21H. In the anti-terrorism bill, now if you look at the new bill, the revised version of the bill, the definition of terrorism has been articulated in Section 3, the clause 3 of the bill. And if we were to look at it carefully, there are instances in which a protest, a civilian protest, that can escalate out of hand, where damage to public property might take place, all in the context of a protest, will be deemed an offence of terrorism. Now the question needs to be asked, in a situation like that, would ordinary law be more appropriate, where, say, someone who has overstepped the mark will face consequences under the penal code for damaging public property? Or should that entire episode be characterized as an act of terrorism, where a completely different regime, procedural regime of law applies to that individual? And the real devil is in that detail, because the anti-terrorism bill permits a situation in which even those types of activity can be placed within the rubric of terrorism. Now, I go back to that previous point I make. Ultimately, the problem with the anti-terrorism bill is that it strips judges of their ability to have oversight over the arrest and detention of persons. Under ordinary law, if someone is arrested, is produced before a magistrate within a particular period of time, 24 hours or 48 hours, depending on the offence. The magistrate will decide, look at the evidence. That's what the magistrates are trained to do. Look at the evidence, look at the facts, decide whether this person should be remanded or granted bail or discharged. Because that is what the magistrate's job. The problem with the ATA, the anti-terrorism bill, is that once you come within the rubric of terrorism, you have a completely different regime that applies to you, where the magistrate, if there is a detention order in place, has no power to decide what should happen to that individual.
Dr. Gehan, this bit where you are pointing out where there is no magisterial oversight into this matter will most certainly catch the eye and ears of the international watchdogs and the international community, because it appears to be so much against the people. Do you believe that the government of Sri Lanka appreciates the negativity attached to such a move? And what are the real steps that the opposition or other lawmakers and influencers can actually do? What concrete steps can they do, or is it left to this parliamentary majority?
So I think, yes, there is certainly a problem in terms of Sri Lanka's fulfillment of international obligations, and the international community will certainly look at this issue, and there will be raised eyebrows. But even if you leave the international community to one side, the question needs to be asked from a domestic perspective: why are we not trusting our own judges? Now, when we go to the international community, we say we don't want international judges. We don't want international prosecutors. Right? The whole conversation in Geneva around foreign judges was that we don't want them because we have good judges back home. Right? That's what we keep telling the international community. So then the question needs to be asked in terms of the ATA. Why not trust our local judges then? Why are we stripping our local judges of crucial basic powers that they're trained to exercise if the line that we're running is that we need to have only local institutions dealing with issues of accountability, right? So there's a contradiction here. And I think the opposition, civil society actors who are looking at this issue need to point out that contradiction, because I believe that there are good local judges that can handle any situation, any complicated situation, even to do with national security. And we need to be able to trust those judges to do their job. Any law that strips them of that function needs to be looked at very carefully.
Newsfirst, Newsline with Faraz Shaukat Ali on TV1.
Terrorists use Canada as a safe haven. Chinese research vessel hasn't been granted permission to enter Sri Lanka yet. Foreign Minister tells Indian media. IMF unhappy about the collection of taxes. MP Maindananda hints at a new plan to collect tax. Difficult to make ends meet. Need a salary increment. Several trade unions prepared to take to the streets. Chandrika and Maitri attend the Bandar Naika Memorial. Cricket World Cup contingent named. Dasun to lead the team. Vanithu Hasaranga fails to make the cut.
Newsfirst, Newsline with Faraz Shaukat Ali on TV1.
So what's the definition of terrorism? Does it actually define what terrorism is, or a terrorist?
So the bill that we have at the moment has a definition for offence of terrorism, which has two limbs. So the offence of terrorism takes place when you commit certain types of acts, which are the regular acts that you might find in the penal code, like murder, like abduction, even theft, destruction of property, combined with the second limb, which is the intention behind the act, which is often recognized in international terms, recognized as, causing terror within the population, right? So terrorism is essentially doing those things with that particular political motive of causing terror. The problem with the current bill is that it expands beyond that and expands to a point where doing those things, for example, the destruction of property, that, as I said in my previous example, that can take place in the context of a public protest. And perhaps the penal code can be used to punish those perpetrators. But in that context, if you look at the definition in the bill, it becomes an offense of terrorism because the definition in the bill includes as one of the intentions compelling a government to do something. So now if you have a problem with a policy, right, you want to protest that policy, you're trying to compel the government to do something, to withdraw that policy. So then in the context of that attempt to compel the government, something goes wrong and property is destroyed, suddenly that becomes an act of terrorism, which, as I said before, the consequences of that is that you have a different procedural regime where judges have no oversight in terms of your welfare and your ability to get bail, to be remanded or to be discharged.
When you look at the various releases from our prison system of people who've been accused of terrorism, most notably people who were supposedly, allegedly members of the LTTE back in the days. A few months ago we had two people who were released after several years of incarceration. They had been convicted, but there have been instances of people who've been held for a long time, I suppose under the PTA, and then only to be released several years later. Is there any facility or an ability from the government to pay reparations, compensation?
Yeah, that's a tough question to really tackle, because often when individuals are held long term and then they go through their trial and they're finally acquitted, years after actually being arrested and then detained for almost the maximum period of the actual sentence, right? So you have individuals sometimes who have been in remand for over a decade and then finally acquitted. Their remedy can be often a civil case for wrongful prosecution. But that's a tough option, because they are looking at going back into the system and spending years in litigation to secure damages. I don't think that's an option that is a viable option for many people who go through that trauma.
Yeah.
So an alternative where reparation is considered is definitely something that should be discussed. There's a law that is called the Office for Reparations Act, which was passed a couple of years ago. That law, unfortunately, does not deal with this type of case, if I'm not mistaken. And perhaps this type of case where individuals have been subject to persecution through arrest and detention for a long period of time should have an option to seek compensation from the state. The state, on a case-by-case basis, can consider that. So that's a very good question, and I think something to seriously look at. Yeah.
As we come towards the sort of, or just over the halfway point, can we talk about something else also that is currently in the news and which might perhaps catch the attention of the youth of the country and others, and that is about this online safety bill. What do you identify as the most problematic matters in this online safety bill?
I think there are two problems here. One is the actual text of the bill, and I will talk a little bit about that. The other is the timing of the bill. It's curious that we are in a context where existing criminal law that deals with online activity, a classic example being Section 3 of the International Covenant on Civil and Political Rights Act, ICCPR Act. And you also have the Computer Crimes Act. The existing law has been routinely misinterpreted and misapplied to situations that have nothing to do with the provisions of that law, right? So that's the prevailing context. There's a lot of criticism around the misapplication of Section 3. In fact, the Human Rights Commission back in 2019 issued a set of guidelines to law enforcement, wrote to the Attorney General, wrote to the IGP saying, these are the guidelines in terms of how this particular section needs to be interpreted, because we notice that it's interpreted in a way that's not consistent and even-handed. And we continuously have these instances where individuals that have nothing to do with, or have done things that have nothing to do with the section which deals with incitement to violence, are being arrested and then finally detained without bail for a period of time, only to be discharged when it is discovered that this has nothing to do with the section. So that's the prevailing context. Now you're trying to, in that context, enhance the legal regime where law enforcement is expected to interpret a new law and apply it in good faith. So my concern here is that I think institutional reform needs to precede any enhancement of the law, because I think the law enforcement authorities need to have the capacity and will to interpret existing criminal law in good faith before we start talking about expansion. So that's about timing. As far as the content of the bill is concerned, there are a number of problematic features. I'm happy to talk you through them.
Yeah. Well, why don't you give us one or two points that you...
One would be the breadth of some of the offences. Now, prohibited statements are defined in the bill, and one of the problems with that definition is that statements that cause distress are included within the definition. So one example in clause 22 of the bill is that if someone posts a photograph of another person, that person expected would be kept private, regardless of the nature of the photograph. It need not be intimate in nature, it need not be sexual in nature, it could be just a photograph of that person. If that person posts that photograph and the other person encounters some distress, there is an offense committed. Now, that's a very serious expansion of our criminal regime, because up to this point, that was a domain for civil proceedings. You can file a case for damages and injury if you feel some kind of injury as a result of some action. That's a civil case. That's the whole point of moving criminal defamation out of our penal code and confining it to the civil proceedings. So now you have a situation where even that kind of activity is a criminal offense, and you will have a proliferation of complaints to the police where people feel distress, because distress is something that is very subjective and not apt in terms of a standard for criminal law. The other expansive offense is in clause 12, where a false statement that threatens national security suddenly becomes an offense. And here we're not talking about things like leaking sensitive information that can be a threat to national security. We're talking about a false statement. So the question is, what is national security? How do you determine a threat to national security? Are we going to end up in a situation where even an accusation, even a campaign can be seen and framed as a threat to national security? Again, look at the existing law. The Computer Crimes Act has a provision that refers to national security, and it has been deployed to arrest people for things as trivial as, a false rumor about the head of state having COVID. Now, during the pandemic, people were arrested on grounds of national security for things like that, instead of the simple response like a correction or a statement denying the rumor. That people were arrested. So I think there's a concern that these types of offences with that kind of breadth and vagueness can be used selectively and abusively.
Tell me, Dr. Gehan, what is anything else in this online safety bill that we may not have mentioned before that could, in effect, be rather very problematic?
Yeah, I think one of the other features in the bill that I think will raise some eyebrows and cause a lot of concern is Clause 19 of the bill, which criminalizes any type of impersonation. Now, the margin note in that, or the margin clause, how it's described as an offence, says cheating by personation, but the elements of that offence doesn't have cheating as an element, which means that any type of impersonation online will be criminal, will be a criminal offence under this new bill. That will effectively cover things like satire, parody, where you, on purpose, for the purpose of your satire or your comedy, you will pretend to be someone you're not, and that's understood. And I think that will be a very problematic feature in the bill, because there is a freedom to use online spaces anonymously, to engage in satire, in parody, which will be affected by that clause if it's not dramatically revised. So that's another feature in the bill that needs to be looked at.
Dr. Gehan Gunatilleke, thank you very much for your time with Newsline.
My
much
pleasure.
appreciated. Yeah. And that's the way it was on Newsline, this edition, where we came to you from London. And here's me wishing you a very good evening, as much as you can, of course. And God bless you all.